Hello guys and welcome to another video of the Administrative Law series, and today we are going to learn about Lokpal and Lokayukta. Now if you have been with us throughout this Administrative Law series, you must be knowing that there are various branches and various agencies of the government. We have also learnt about whenever we give too much power to these agencies, it leads to abuse of power, and whenever there is abuse of power, obviously it leads to corruption. Therefore, it was understood that there was a need for an anti-corruption body, but this did not happen until 2013. Therefore, the Lokpal Act of 2013 was passed, wherein it was regarded as an anti-corruption body which will look into the complaints which regards to the corruption of the administrative bodies. Now throughout this video we are going to refer to the term of ombudsman a lot, so let's look into the meaning and the origin of the term ombudsman. Now ombudsman is a term which is originated in the Scandinavian countries. It was regarded as the parliamentary body supervising judges, government and other officials and ensuring that they are complying by the law. Now this concept was introduced in the Swedish constitution in the year 1809. Later on, this concept started becoming popular after the World War II. Many countries then started incorporating this concept in their judicial system. Now, when this concept was introduced in Sweden, it was very strict in nature. Therefore, when this concept was spread all across the world after the World War II, the concept was adopted as per the culture, as per the economic situation and as per the political situation of each countries. So it was not necessary that this concept was taken into as strict sense as it was taken as per the Swedish constitution. Now let's look into the development of the anti-corruption body and anti-corruption law in India. Now with regards to India, the law with regards to corruption is not even a decade old, as the law came recently in the year 2013. Though it was proposed and suggested by Ashok Kumar Sen, the law minister back in the 1960s. Now the terms Lokpal and Lokayukta were coined by Dr. L.M. Sanghvi as the Indian model of ombudsman, when the law was passed in the year 1968, but it was soon lapsed. Ever since then, and the Lokpal was introduced more than 9 times to be successful only in the year of 2013. Therefore, the Lokpal bill has been introduced in the year 1968, 1971, 1977, 1985, 1989, 1998, 2001, 2011 and finally it was passed in the year 2013. Now similar to India, there are total number of 8 other countries which have active anti-corruption laws passed in their countries. These countries include United Kingdom, Spain, Burkina Faso, Netherlands, Austria, Portugal, Finland, Denmark, Sweden and finally India. Now if you look into the composition of the Lokpal body, there are total number of 8 members and a chairman. Now this chairman needs to be either a judge of the Supreme Court or Chief Justice of a High Court, or either he has to be an eminent person or either he can be a person with a clear image and expert in the field of anti-corruption, vigilance, public administration, law and management and finance and including insurance and banking. Now furthermore, the select committee to appoint Lokpal includes the Prime Minister, Chief Justice of India or his nominees, Lok Sabha Speaker, Leader of the Opposition and a person nominated by the President of India. Now a removal of such member can be done only when there is a petition which is signed by 100 members of the Parliament. Furthermore, obviously there are investigation which is done by the Supreme Court, who later on sends the report to the President for the removal of such person. Second method is when the President himself will choose such a person to be removed and later on ask the Supreme Court to do such an investigation on a matter. Now Lokpal furthermore has various important powers. Now such powers include giving direction to the CBI, further referring to cases to CBI. No transfer of the officer can be done without the approval of the Lokpal. This is with regards to any cases in relating to CBI. Okay, so whenever there is a case which is relating to CBI, if any decision is made by CBI to transfer an officer, such an officer cannot be transferred without the approval of the Lokpal. Okay, further on, there is an inquiry wing of the Lokpal, okay, which has a similar power to that of the civil court. Now, such powers include to summon and enforce the attendance of any person and to examine him on an oath in matters that require discovery and production of any documents. Okay, so whenever there is a production of any documents, even to send summons, which are powers similar to that of the civil code. Furthermore, it also receives evidence on the affidavit. Okay, moreover, to request any public record or copy of any office. Similar to that of civil code, the Lokpal also has the power to request any public record, okay, or any public document for the purpose of the case at hand. Okay, and finally, it also has the power to issue commissions for examination of witnesses and the document, which if you go to see, which are quite similar kinds of power which that of the civil code. Furthermore, the Lokpal recommends suspension and transfer of public servant connected with the allegation of the corruption. Okay, so the Lokpal has a power to recommend any suspension, okay, of any public servant in case his name is involved in that of corruption. Okay. Finally, the Lokpal has a power to give direction to prevent discretion of the records during the preliminary inquiry. So, okay, so this is a quite similar power to that of the civil code. Now, furthermore, let's look into who can be investigated by the Lokpal. Okay, so as per the Lokpal Act, it can investigate a person in 7 categories, namely Prime Minister if he or she demits the office, okay, current and former cabinet ministers, current and former members of the parliament, all the class 1 officers of the central government like secretaries, joint secretaries, etc., all the class 1 relevant officers of the public sector undertaking and other government bodies, directors and other officers of the non-government organization which receives funding from the central government, directors and other officers of the non-government organization which receives the fund from the public and which has annual income of more than 10 lakhs from a foreign contributor and receives 1 crore from the government. Now, let's look into difference between the Lokpal and the Lokayukta. So, the Lokayukta operates on the state level, while the Lokpal is a central body, so it operates on the central level. Lokayukta is to set up investigation of individual complaint against the public servant. Okay, so here there is an individual who is having his grievances towards any public servant, or he can also file towards any politician with regards to corruption. Whereas in the Lokpal, it is established to investigate the civil servant or a politician with regards to the corruption lodged by any person. Okay. Furthermore, the Lokayukta has all the members of the Legislative Assembly and the state government employees. Okay, so under the Lokpal, there are all members with regards to the Legislative Assembly and the state government employees. But under the Lokpal, all the members of the Parliament and the central government employees. Okay, so here under Lokayukta, we have the members of the Legislative Assembly, and under the Lokpal, we have the members of the Parliament and the central government. Furthermore, Lokayukta members are appointed by the governor, whereas the Lokpal, being the central body, is appointed by the president. Under the Lokayukta, there are 3 member bodies who are appointed for the period of 6 years, whereas under the Lokpal, we have 8 member body. So that's all for today's video, guys. My next video is going to be about various cases with regards to the administrative law, basically important cases with regards to the administrative law. I'll see you all soon. Take care. Bye.